When I named the company West Coast Franchise Law, I could just as easily have named it West Coast Leasing Law because we do a lot of leasing. A lot of our clients full service and we help them with the franchise stuff, but more so we are a firm that helps our clients lease, develop, and buy different locations and just grow and develop more stores. And what that translates into is a lot of leases. Leases where we're just leasing the dirt and building the building. Leases where we're doing an inline thing. Leases where we're on an outlot in a larger mall. Drive-through, no drive-through. All these leases have a few things that you got to look for and that you really, really don't want to have in your lease. If they persist in the lease, I will actually tell my clients to walk away. One is you have a lease, so it's for a term of 10 years. There are options for an extension. So you might have a 10-year lease with 4 or 5-year options, or 5-year lease with 3 5-year options. Whatever it is, you've got options to extend the lease. And if the lease says those options are personal to you, the current tenant, meaning that if you assign the lease, they go away, that doesn't work. And it doesn't work because when you go to sell your business, those options won't be there. There's not really anything good about that in the context of a sale. It introduces uncertainty, and the way it plays out is that the landlord now has the opportunity to renegotiate the rent. What that does is increases the buyer's costs, and so the buyer looking ahead thinks, well, I'm not going to make as much money as I thought because the expenses are going to be greater, and now your purchase price is going to get messed with. Even if that doesn't happen, they still have to go to the landlord and get this all sorted out, which creates uncertainty, creates questions, creates stress, creates tension, none of which you want in a transaction. And so it's just bad. And so that can't be there. And it's one of the few things where I believe that deals should be deals and legal should be a supplemental or a piece that exists alongside. Legal should not dictate the deal. It should, the legal aspects of your transaction are things that can be managed and should be worked out and sorted out so that you can do the deal that you want to do. But if your lease has this in it, it is one of the few times where I will say, look, if you will not take this out, my advice to my client is to walk away from this lease. The other reason you need the options, or your buyer might need the options, is for financing. If you finance your transaction, you finance your build out, whatever it is, you need as much. Banks want as much term in the lease as there is term for your financing. So if you have a 10-year note, you can pay the bank over 10 years, you need 10 years on the lease. And so if your buyer comes in and it's year 6 of the lease and they get a 10-year note and the options go away, that doesn't work. The bank isn't going to finance that. But if they have options, 4 years in the lease and some 5-year options after that, it's fine. Some other things we look for that are concerning. If you're an inline store, you're inside like a strip mall, sometimes it'll say, we can move you. The landlord can move you. And we can do all kinds of negotiating around the terms of that, what the landlord has to pay for. But it's never good if you're moved. It's going to be disruptive. You're going to be shut down. However much money the landlord has agreed to give you is not going to be enough. And while you're closed, you're not going to have your employees working. They're going to go somewhere else. We can't have the move out clause. And if the landlord wants a move clause, we need it to be at our option. We can say yes or no. Another issue that we look at leases, this is not a huge no-no, there's just a better or worse. Do your options have the amount of rent spelled out? Or is it's just going to be market rent when we get there? That's not uncommon, that it's uncertain, that it's going to get repriced, that you don't know what your option rent is going to be. I like to try to put some bands around that. It will be not more than, but better if we can just pick the rent now, because what landlords know and what I know and what you will now know because you've listened to me is it's market rent's going to be higher than that option rent. It's just the way it goes. Another big no-no when it comes to leasing is similar. Another big no-no when it comes to leasing is the kick-out clause. Can they just kick you out? And some developers will do this because they're sitting on the plan that they're going to develop the land into something else. And so when they get there and they get their permits or they get their financing, they want to be able to kick all the tenants out. And we do not want that, because you get your business going and then they can terminate the lease and kick you out. It's not good. Another big no-no, which is similar to your options don't exist if you assign the lease, the assignee, the new tenant, your buyer doesn't have the options, is probably a bigger cliff, which is if you ask us to assign the lease, if you bring a buyer and you want to assign the lease to a buyer so you can sell your business, the landlord has the right to either cancel the lease and recapture the space or renegotiate the rent. This is another one where if it's in there, I will tell my clients to walk away. We cannot have that uncertainty, net control. I've had it literally where people have showed up with leases. If you send us a notice of assignment or request for assignment, we can terminate the lease, just right there. This absolutely doesn't work for reasons that are just obvious. Some things that we like to have in the lease that are things that you can look for in your lease, and when you're getting anything about it is, and it's sort of deeper issues, eminent domain, the ability of the government to take land. Often there's a focus on how much are they going to take, and you have to stay if they take less than this much, 20% of land. Sometimes it says, oh, the rent's going to get redone. I prefer to look at the reality. If we are leasing a space, we've got a restaurant in it, and we've got 40 parking spaces in a drive-through. If the city comes along and takes 3 feet off the frontage and it has no consequence to what we're doing, we don't need to renegotiate the rent. That's fine. Who cares? If the city takes 3 feet from some angle or some end of it where we can no longer have a drive-through, we got to cancel the lease because it just doesn't work. We can't do business the same as we did. And so this is something that we put in. If the eminent domain has the consequence that we can't do business in our opinion as tenant, then we can terminate the lease. It's a little bit different look than just dealing with, well, if it's 20% less land, then it's 20% less rent, or 10% or 5%, so forth. It's nice to have the option where if the building's damaged, the premises are damaged, and it's the last 6 or 12 months of the lease, you can just cancel the lease so that you don't have to rebuild before you leave in 6 or 12 months.